I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we will be courtroom hopping into the courtroom of Judge Simpson out of the state of Michigan for one of those proceedings we like to call Sovereign Citizens Hall of Fame with sprinkles on top. And what does that mean for those of you that are new to this? This is a non-sovereign citizen case, and it's actually going to be a follow-up on one of our cases that we've shared here on the channel that was non-sovereign citizen, which I think we only have a few, but this is the case of Mr. Larry Lee. Now, I was going to run down what he went through in his first proceeding, but I don't want to spoil it for you guys that haven't seen it because I am going to add it to this video. So this is going to be his previous proceeding, which was a few days ago, and his original proceeding, which I think was about 2 weeks ago. So I'm going to share that with you guys. What I'm also going to do is I am going to leave my previous commentary at the end of the first proceeding, and then I will add a new commentary at the end of the second. And with that being said, guys, let's go ahead and jump into Judge Simpson's courtroom.
Courthouse case, People versus Larry Lee.
Your Honor, Mary Tanha, Assistant Prosecuting Attorney about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What is that noise?
Right. Shouldn't you check? I don't feel safe.
What
Why are you just pointing? What?
Don't stop at some.
It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, no, you are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want it documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
Hold it, but does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Kwasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Kwasny agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
He might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right? Has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you. Can we get Mr. Lee out? No, oh, is he? Okay. Right. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry.
Mr. Rubio. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Arabo sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Arabo, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Quasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
well,
Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that. But I just wanted to make a record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say
Yes.
something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow up.
Mr. Rob.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what is being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks because in over 10 years of practicing, I've never seen something like this where a victim turns into a defendant. What? During a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and sort of listen to the call. I can give my decision.
You have to go back.
To you. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tan, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Larry Lee.
Okay. The issue is in this case that, first of all, we're adjourning the hearing.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody's very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
and I
me.
understand that.
And Mr. Lee
I
is
think
about jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in
Okay.
the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Well, guys, we have come to the end of this proceeding, and man, this definitely had a whole lot of stuff going on. I am glad that I checked this out. Just to start off, Mr. Larry Lee, obviously he's not feeling his attorney, Mr. Burgess. He claims that this whole phone call started because he just wanted to prove that Mr. Burgess was, not representing him correctly. But later on, we hear that it's a possibility, allegedly, that Mr. Lee did this because he wanted to try to bargain with Mr. Kwasny. You know, you don't testify. In my case, I don't testify in yours. You know, everything works out for everyone. But guess what? It didn't work out for Mr. Lee. And Judge Simpson wasn't having it, especially after he heard the phone call. He said, listen, I'm not going to say, you know, it's a super crazy phone call, or he got, you know, wild in the phone call, or, you know, it was super blatant, but he said enough to feel like, listen, he's violated his bond. He's tampered with a witness. We heard Mr. Kwasny's attorney say the same, like, listen, something has to be done here. And Judge Simpson did exactly that. Revoked his bond, revoked his privilege to speak on the phones in jail. So I don't know. We're going to see how this all works out. I'm going to try to follow this case and stay on top of it. Definitely interesting with what's going on here. I want to look up and see, and I should have did this before I looked into this case, but I need to look up and see what really happened between these two individuals. And because it sounded like it was something very serious. You know, I don't know if it was a fight, you know, because they're calling Mr. Kwasny the victim. It sounds like Mr. Lee tried to trump up some charges on him after whatever went down. But it might, whatever it is, it may have gotten physical. But who knows? We will see. We see that Mr. Lee tried to, you know, he was very adamant in saying, listen, I got evidence that Mr. Burgess told me that this was okay to do. And we see Judge Simpson was not trying to hear that one bit, because obviously he has a relationship and knows Mr. Burgess. But who knows? We will see in the next hearing, the next proceeding. Maybe Mr. Lee really does have that. Maybe Mr. Burgess misspoke in their conversation. We just don't know. But hopefully we will be able to get that footage, that next proceeding for you, to stay on top of it, so that we can all see how this whole thing works out for whoever's on whoever's behalf, and in whoever's favor, because right now it's just like a toss-up. But with that being said, I know I've talked enough. Thank you for joining me on today for this non-sovereign citizen case. I will have more for you here and there. With that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court and the Sprinkles on Top Court is adjourned. Thank you guys for joining me, and God bless.
They were ready. Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Townhouse, Assistant Special Attorney, by People.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir? Larry Lee. All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted, as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication, to the extent the privilege would still exist, between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw, and basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in our office mail, or however it got to me, a letter from the defendant saying, all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Fact. Are we talking a 1 month or a 2-week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the time to
right.
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just 2 pages.
Correct, Your Honor.
He's provided copies too, Judge. He was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say from the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns for the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes,
I think I'm gonna be honest with you. I think you're just telling me yes, thinking that you're gonna get a quicker date. And I am not clear that you're ready to go because you only talked about two pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
That's not true, Judge. I gave it to him on May 8th. He was at my office. He got a
Or the
copy.
2 pages, yes, that's what I have. The
No.
other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage. That again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. If you're, no.
Do you still? Ms. Wyler. Um, would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Should be available. And August 8th, Your Honor?
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to? So if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here on this visitor's waiting since this morning. Victim has also been here previously for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm going to be done. If you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay. We're going to go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right. I'm just.
Double checking. Stage works.
Pardon?
Stage works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the fourth degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim is, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You
Yes.
understand that, sir? And you understand that you will not be, the court is not going to treat you worse, and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
You know, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, is that and the bond violation. Yes.
The defense is requesting you to examine the information between myself and my attorney, because I am alleging that I did not violate the bond, the condition of the no contact order of my bond, and witness tampering that the prosecution says that I'm guilty of, and the text messages prove.
You're asking me to look at information that would be relevant to the bond hearing?
The text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
And I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you.
Well, guys, we've come to the end of both of these proceedings. And as we can see, Mr. Larry Lee has appearance coming up on August 8th for that bond hearing. And we remember what happened in that first appearance. And I don't want to go into that, being that I did the commentary on that. But witness tampering, you know, he's already in trouble for criminal sexual conduct. You know, it just seems like a lot is going on here. So for him to want to represent himself and not want his attorney there, his attorney obviously, you know, finding out that he doesn't want any representation or doesn't want him on the case, obviously he's going to withdraw and feel some type of way on it. But, 1 minute he wants counsel, 1 minute he doesn't. Now he's saying, he possibly wants standby counsel. We can see Judge Simpson getting all flustered about the situation. But it seems like Mr. Lee is trying to hurry up and get this thing over with. But if you know anything about the court system or ever had to deal with the court system, they're going to go at whatever pace they decide to go. So it's going to be interesting as we follow this case. For me, hearing the details of it, of what really happened, because, criminal sexual conduct is a serious thing. We heard Judge Simpson, talking about sexual offender stuff and DNA and all these different things. So it's definitely pretty serious situation. But with that being said, guys, as always, I appreciate you guys joining me. This is Sovereign Citizens Hall of Fame. Don't forget to like, share, subscribe, and comment. And with that being said, Sovereign Citizens Court is adjourned. Thank you, guys. God bless.